Professions here today. So today's presentation are student athletes, employees. Today's speaker, Naima. I just lost it that quickly. Naima Clarke is a supervisory attorney in Region 9 of the NLRB, National Labor Relations Board, and has been working as a field attorney since 1995, started working in the board's Buffalo, New York office since then, and then be transferred over to Cincinnati. In this role, Ms. Clarke was responsible for investigating and litigating unfair labor practices, presiding as a hearing officer in contested representation and election cases, and serving as counsel for the NLRB in federal district court proceedings. She now supervises a team of field attorneys and field examiners in performing the same activities. Ms. Clarke has presented at various continuing legal education seminars on behalf of the regional office and regularly outreaches on behalf of the region. Ms. Clarke serves as the region's Equal Employment Opportunity Officer and has done so since 2000 to 2015, and is also an adjunct professor at Northern Kentucky University, Salmon P. Chase College of Law, and has taught labor law from 2010 to 2014, received a BBA from Ohio University in 1990 and her JD from the Ohio State University, Moritz College of Law in 1995. And we are very excited, as I said, to hear today's presentation. We do ask that you keep your cameras on for the duration of the presentation. And we will ask also that if you're seeking CLE credits, that you will keep an eye on your chat, because we will be putting out requests at least once per half hour that you will enter your attorney name and number. So please keep an eye out for that. And with that, I will now mute myself. So thank you very much.
Thank you very much, Kate. And, don't feel too bad. You did better with my name than my fourth grade teacher did after spending an entire year as her student in her classroom. So it's quite all right. Thank you so much to everyone for having me here today to speak to you about the subject of scholarship players at academic institutions and this question of whether or not they are considered to be employees. So a little bit of housekeeping here. I do not have a pretty PowerPoint to share with you all. I know these days people like the bells and whistles while they're learning. So hopefully I can provide that in another way by throwing in some very awkward football references and humor in some of the headings. I will share with you an outline that I have that I prepared that you all also have. So I'll put that up so we can kind of follow along on that. I'm going to share it on my screen.
And it has been uploaded to our chat log. So if you would like a copy of it for yourselves, please download it now.
Okay, can everyone see?
We can, thank you.
Okay, so you just see the screen and not me, is that right? My screen kind of went.
What we see, it kind of depends on what viewing mode folks are in. For instance, I'm in one that's not quite full screen, but I still can see the speaker.
Okay, I see now. I see now. What happened, what threw me off is that the screen with everyone's wonderful faces sort of moved on me and I couldn't see everyone. So I couldn't tell what was going on. So I'm gonna try to kind of put things side by side here. So I can see things. Okay. As Kate mentioned, I've been with the National Labor Relations Board 27, going on 28 years now. Started out in the Buffalo office and now here in Cincinnati. And I'm a supervisory attorney. I don't want to make any assumptions about what everyone knows about the NLRB and how it operates. So I'm going to begin by giving you all sort of overview of the agency, and then kind of go into what the National Labor Relations Act is all about, and then cover the first case that really introduced this issue to the board within the context of the National Labor Relations Act, and that was in 2014. So the agency has sort of been grappling with this issue since then. And then I'm going to move into where we are now on this question. So I'm excited to hear that you guys have been discussing this within the break room, and I do welcome, any questions. Primarily, I'll be presenting things from the viewpoint of the general counsel of the agency, who is my boss and who's the chief prosecutor for the agency. So basic introduction to the National Labor Relations Act. Well, let me start with the board. The board is an enforcement agency comprised of two sides: the general counsel, who is, as I said, the chief prosecutor, who's responsible for investigating and prosecuting unfair labor practices that is carried out initially at the field level, in the regional offices around the country. We have regional offices in every major city, and we cover the entire country through the regional offices. Field examiners and field attorneys investigate the cases, and the field attorneys prosecute them. On the other side is the board, and that's a 5-member panel of presidential appointees. The general counsel is also a presidential appointee, by the way, and that is the adjudication side. So they hear the cases. This is an administrative agency, though, so there's an administrative proceeding. The cases, both unfair labor practices and representation cases that I'm going to get into, that go up to before the board. So those are the two sides. So the purpose of the act is meant to promote labor stability and to equalize bargaining power between employees and employers. The core rights of employees can be found in Section 7 of the Act. So Section 7 of the Act states that employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, and shall also have the right to refrain from any or all of these activities. So you have the right to engage in activities whether or not a union is present. Oftentimes when you say labor, most people, both professional and lay people, believe that the board only gets involved in cases where a union is involved or a union wants to represent employees. But in fact, a lot of the cases that we get, especially now, involve situations where there is no union involvement. A lot of them concern employees actually working together or taking action concerning their terms and conditions of employment without any union involvement. So that's Section 7, and that is sort of what I think is the heart of the act, because it goes to the employees' rights. So the Act's aims are achieved by promoting collective bargaining and protecting employees' rights to act together to vote for a union or to act together for their mutual aid and protection, whether or not a union is involved. I don't want to throw everyone off by the way I scroll here, so let me know if that's a problem. So what does it mean to act together for mutual aid and protection? This is also referred to commonly as concerted activity. So if you deal with any board cases or practice before the board, you will hear discussions about protected concerted activity. So the question there is it protected by the act? And secondly, is it concerted, meaning is it group activity engaged in by one or more employees? Well, can group activity be engaged in by only one employee? Yes, it can in some circumstances. For example, discussing pay and other terms and conditions of employment with coworkers is an activity that's considered to be inherently protected. So if I go to one of my coworkers and I say, hey, this is how much I'm making an hour, how about you? Even if that employee doesn't answer the question or doesn't want to be involved in that conversation, is considered to be concerted and protected by the act. And any limitations or restrictions on that activity would constitute an unfair labor practice. And why is that? Briefly, because the group activity normally begins with one person. And so if individual activity is looking towards the group and involving the group, it's considered to be concerted. And why is it inherently concerted? Because terms and conditions of employment, discussing those terms and conditions of employment, that is the sort of nascent activity that is a precursor to most group activity. If you don't know how others feel, if you don't know if they're happy with what they're making or if they're happy with what's going on in the workplace, then it's hard to sort of coalesce a group around some issue. So also bringing group concerns to the employer. So you may be an individual employee, but if you've spoken to your coworkers, you have an issue you want to present to the company, and you go in there alone and do it, but on behalf of the group, that is also protected. And so what does it mean to say it's protected? It means that any infringement on that right, discrimination for exercising that right, or retaliation would be considered unlawful. So there are two types of cases that come before the board that we handle. First, there is the representation cases, and those are cases in which a union has petitioned the agency to hold an election for employees to vote on whether or not they wish to be represented. There is a lot of procedural steps involved in that process. And we do handle that. That begins in the regional office. Everything begins in the regional office. And I'm not just saying that because I work in one, but it's true. So a petition is filed, and a lot of times there are issues that may need to be resolved if the union and the employer involved can't agree on who will be included in the bargaining unit for collective bargaining, for example, who is an employee, which we're going to hear about more as it relates to players at academic institutions. So you may have heard when Kate was doing the introduction that one of the jobs that I did was to preside as a hearing officer. So we will hold a hearing to hear evidence from the parties in order to resolve that, if those issues need to be resolved before an election can even be held. So that's the representation side. The board, the 5-member panel that I told you all about, is vested with the authority to oversee the representation process, but they have delegated some of that authority to the regional directors in the regional offices, which is why at the regional level, we conduct the hearings, we conduct the elections, we resolve initially any pre-election issues that arise, but that is subject to review by the board. So on the unfair labor practice side, the Act delineates a number of, has sections that delineate the types of conduct that are considered to be unfair labor practices. And these provisions protect employees from conduct by employers and unions that interfere with or restrict their rights under Section 7. So, who is an employee within the meaning of the Act? This is an important and threshold question because entitlement to the Act's protections turns on whether or not you are considered an employee. So this is how the Act defines employees. The term employee shall include any employee and shall not be limited to the employees of a particular employer unless the Act explicitly states otherwise, and shall include any individual whose work has ceased as a consequence of or in connection with any current labor dispute or because of any unfair labor practice, and who has not obtained any other regular and substantially equivalent employment, but shall not include any individual employed as an agricultural laborer or in the domestic service of any family or person at his home, or any individual employed by his parent or spouse, or any individual having the status of an independent contractor, or any individual employed as a supervisor, or any employee covered by the Railway Labor Act. Or, and I place the emphasis here, by any other person who is not an employer as defined herein. So we'll take a look at how the Act defines employers. This beginning language has to deal with just agency, but what I want to you to take note of here, first and foremost, is that the Act covers the private sector only, not the public sector. So you see that here, no, does not include the United States or any wholly owned government corporation or any state or political subdivision thereof. So this comes up obviously in the case of student players because many academic institutions, colleges and universities are public institutions. So the board has, who or is not an employee is in many cases an easy question, but it is often not an easy question. And so how do we decide whether or not a person is an employee if that issue comes up? So the board applies a common law standard, the common law rules of agency governing employee-employee relationships. So, and which defines an employee as any person who, one, performs services for another, and is two, subject to the other's control or right of control. That might describe the parental relationship. So it may lead one to wonder, is my child and also an employee entitled to the Act's protections? I don't know. But consideration, payment is strongly indicative of employee status. However, it is not dispositive under common law agency standards. So in applying this standard over the years, the board has, prior to this issue of players coming up in 2014, the board looked at other students who either sought to be classified or sought to have the Act's protections as employees or sought to be represented by a union as employees. Some of the cases that in which the board has grappled with this issue include this line of cases under Brown University, where the board considered whether graduate student assistants were employees. And as you can see here, the board has, I don't like to use the term flip-flop because that suggests that no real rigorous consideration was applied and it's just politically driven. It has not been, but it's not been an easy issue. So the board has gone back and forth, but currently, in this case, Columbia University, which the board issued in 2016, the board reaffirmed its position that student assistants in colleges and universities are employees under the Act. You should also know that the board's current general counsel, Jennifer Abruzzo, maintains the prosecutorial position that this would include medical interns and non-academic student employees. The board has also found that student janitors are statutory employees as well as student cafeteria workers. So now's the time for my first awkward football reference. So hopefully that'll get everyone's attention here. Where are we and how do we get here? The road to the employeeship, which is not a word. Northwestern University. That was a case of first impression that started its way to the board in 2014 with the issuance of a decision by the regional director of our Chicago office that Northwestern football players in the program were employees within the meaning of the act. So that case actually made a huge splash and was a momentous occasion for me, not just because this was a case of first impression and very interesting idea of athletes or scholarship athletes actually being employees and having protections as employees, but it was the first time that my son, who was 16 at the time, really took notice of my job and the work that I do. And that's because he is an athlete, very interested in sports, and knew when I got home that these football players were considered employees. So this story was picked up by the media very quickly and spread even down to teenagers and helped my son to understand the work that his mother does and the agency that she worked for. Prior to that, I don't think he paid too much attention to that. So a little bit about the Northwestern football program, just to put this in context. The Northwestern football program is an NCAA Division I school in the Football Bowl subdivision. So these are all from 2014. Some of this might have changed by now. Like the conference that they're in. So if it has, my apologies, but this was the posture at the time this decision came out. The Football Bowl subdivision was described as the highest level of play for college football and comprised of about 125 schools. They were also a member of the Big Ten Conference. The structure in which they played, league play, was typical of what you would find in most Division I schools and Division II as well. So the NCAA dictated many terms and does dictate many terms in which the players play and compete, such as the maximum number of grant and aid scholarships the school can award, caps on the number of players who can participate in preseason football practices, minimum academic requirements for eligibility, terms of their scholarships, the amateur status that they must maintain, and the number of mandatory practice hours that can be imposed on the players. The Big Ten also regulated various aspects of their scholarship, their play, what they would receive. Primarily, they dictated the wording in the scholarship tender, and that's the word that was used in their scholarship agreements that a player would receive. And those terms specified that the scholarship award is subject to the player's compliance with the school's policies and the NCAA's and the Big Ten's regulations. In terms of revenue, the football program generated some $30 million in revenue during the 2012-2013 academic year, and about $235 million over the prior 10-year period from ticket sales, broadcast contracts, stadium rights, and merchandise sales. Now, one of the things that Northwestern pointed out was that the amount of expenses that went into earning that revenue, and they really describe it essentially as a break-even proposition for them. But I'm including this here to point out how much revenue is generated in these football programs. It is in the billions and it's big money. During the 2013 and 2014 academic year, scholarship was worth about $60,000 a year, but none of the money was directly dispersed to the players. So initially, how did the case get to the board? A group called the College Athletes Players Association filed a petition to represent the players, Northwestern's football players who received grant and aid scholarship. So this issue obviously was not one that Northwestern was willing to say, okay, yeah, we agree they're employees. We'll agree to the terms of an election and let's hold it and see if these guys want to be represented by this Kappa group. No, what happened was there was a pre-election hearing held and the regional director issued a written decision after that hearing, finding that the players were employees and directing that an election be held. So the board granted review in this case. And when it got to the board, and here's my second awkward football reference, the board famously punted on the question of whether these players were employees within the meaning of the act. Instead, what they did was decline to assert or exercise jurisdiction, which is discretionary on the board's part, to exercise jurisdiction over the representation petition because the board believed that it would not effectuate the policies of the act for them to assert jurisdiction. In other words, it would not promote stability in labor relations. Although the board did note that the player status as students who are also athletes receiving a scholarship to participate in what has traditionally been regarded as an extracurricular activity did materially set them apart from the graduate student assistants and student janitors and cafeteria workers whose employee status it had considered in prior cases. So what the board was really saying, and if you ever take a look at this decision, is this is hard. And we see a lot of issues with finding that they are employees right now. Some of them, ironically, were based on factors that made these FBS players more akin to professional employees, professional sports employees, but that made it difficult for the board to assert jurisdiction. So here's some of the things that the board pointed out. Notably, the symbiotic relationship among the various teams and the conferences and the NCAA. So the NCAA sets these common rules and standards that govern the competitions. They exercise a substantial degree of control over the operations of the individual member teams, and including many of the terms and conditions under which the scholarship players practice and play the game. And so this is sort of what the same sort of relationship and form of sort of regulation that makes professional sports what it is, right? These uniform rules of competition and compliance with these procedures is what attracts us all to the sport. In other words, the product is based on these sort of terms. So the board said that, labor issues that would directly involve only an individual team and its players would necessarily affect the NCAA, the Big Ten, and the other member institutions. So you couldn't really have this one discrete group of players who are represented by a union. And if, for those of you who know how collective bargaining works, the employees sit down with the employer and every term and condition of employment is on the table. So terms and conditions of employment, such as even the scholarship compensation, the hours of work, the criteria, the requirements, all of that could be up for discussion were these employees to be considered employees and to select a union to represent them in collective bargaining. And so you sort of have this one group, and then everyone else who's in the league are operating under different terms and conditions. The board also noted that they would be precluded from asserting jurisdiction over the vast majority of the college and universities in FBS football because all but 17 of them were state-run institutions. And as you'll remember, state-run institutions would not be covered by the act. And Northwestern itself was the only private school in the Big Ten. A little note here, I attached the GC memo to this outline, and she notes in there that there was a bill introduced in the Senate to amend Section 2.3 of the Act to explicitly list scholarship players as employees, and also to expand the board's jurisdiction to state colleges and universities. I'm pretty sure that has not made its way out of the Senate and, could very much be dead. So, but I just mentioned that to let you know that that has happened. There's a link there, and if anyone wants to check the status on that, you can. Importantly, the board did limit, although they punted, they limited their decision to not assert jurisdiction to the Northwestern's FBS players and the facts of that case. So they did not issue any ruling or make any holding on whether or not they were employees for representational purposes, because remember I said there's two sort of context in which a person's employee status will come up, and that's whether or not they're an employee for purposes of being included in a bargaining unit and selecting a union, and whether they're an employee for purposes of exercising their Section 7 rights under the Act. I wanted to share with you before we move on some of the notable factual findings made by the regional director in that decision that was issued. I found it very interesting, and I think when I read it back in 2014, had not previously really paid attention to what the life of a Division I football player or Division I athlete looks like. And it really struck me how much time that these players put into playing and putting into preparation and participating in sports. So I just wanted to lay some of them out here for you. And really, I think before this, just on a personal note, I would have debate and discussions about whether or not these players should be paid. And we know that's been an issue of discussion and debate. And one side says, well, they are paid. They receive, scholarships. Their education is paid for, tuition and expenses. That should be enough. And on the other side, people will argue, yeah, they generate lots of money for the institutions at which they play. They put a lot of time into playing for these teams. And what they receive in terms of a scholarship is really not in proportion to what they do for the university. So those were the two sides. But after reading this decision, I think just based on the amount of time that they put in, it sort of moved the needle a little bit. Just for me personally, again, I'm not speaking in terms of the general counsel's position, but just on whether or not they should receive some type of compensation on top of their scholarships that they receive. And this doesn't implicate whether their employee status. So the regional director found what the evidence in the record showed that the players were subject to special rules. This is separate and apart from the rules that the remaining student body was subjected to. So for example, freshman and sophomore year players who received scholarships were required to live on campus. Upperclassmen were permitted to live off campus, but if they did, they had to provide the lease to the coach for approval. They also had to get approval to obtain outside employment. At that time, they were prohibited from profiting off the image or likeness or their reputations, which we know has changed based on the NCAA rules change. They were prohibited from swearing in public, subject to drug testing by Northwestern as well as the Big Ten and the NCAA. They were required to wear a suit to home games, and team issued travel sweats away. I noted that those suits that they were required to wear to home games were not team issued. So the players would be required to get those suits on their own with their own money. All freshmen were required to attend 6 hours of study hall each week. So, and what I don't go into here was how the decision really documented how players, who are coming from a family that financially is able to support, their college endeavors, wouldn't necessarily have a problem with the structure, but players who were coming from families who could not, it was a much different story. And some of that is laid out in the decision. Time commitment. The players, basically their time commitment extended well beyond the academic year and was essentially a really regimented year-long commitment to weekly hours that were related to football. So, for example, they would spend 50 to 60 hours per week during the month of August at the training camp. And then during the actual football season from September to November, they spent 40 to 50 hours per week on football-related activities. Then they'd have spring football activities from mid-February to April that took up 20 to 25 hours per week of their time. And then daily workouts from May to the end of the academic year at the beginning of June, home for a few weeks, and then back to campus for summer workouts in July. During this time, they had limited discretionary weeks when they were not expected to be on campus. So, that's a lot of time on top of being full-time students, which they are required to be according to NCAA regulations. So, Office of the General Counsel reacts to ref's ruling and calls a new play. There's my fourth, I lost count, awkward football reference there for you, just to make sure you're still paying attention. So in 2017, then General Counsel Richard Griffin issued a memo taking the prosecutorial position that the scholarship football players in Northwestern and similarly situated players met the definition of employee within the context of unfair labor practices. So I can't emphasize enough that, and I want to tell you a little bit here, I'll take a moment to talk about the General Counsel's authority. I think I told you they oversee the investigation of unfair labor practices. So the General Counsel does not establish case precedent, only the board and the courts can do that. So these memos that the General Counsel issues are public memos intended to explain their policy positions and also to put parties on notice of the positions that they intend to take as a prosecutor, and also to describe ways that the General Counsel wants the board to change the law. So as a prosecutor, the General Counsel is obviously able to put these issues before the board so that they can be decided. So in GC Memo 1701, General Counsel Griffin noted that the Northwestern decision didn't preclude a determination that the players are entitled to the protections of the Act, and the board said that, namely, for the purposes of working together for mutual aid and protection, and that the board left open whether the players were entitled to the protections of the Act. And the board didn't rule that they weren't entitled to be covered as employees for representational purposes either. He also noted, as you all could see from the definition, that players and athletes at colleges are not explicitly excluded by Section 2.3, and that the Supreme Court has recognized the expansiveness of the definition of employee. So applying the common law standard, he noted that athletes play football, in other words, perform a service for the university and the NCAA, thereby generating tens of millions of dollars in profit and providing an immeasurable positive impact on the university's reputation, which in turn boosts student applications and alumni financial donations. They receive significant compensation, including tuition, fees, room, board, and books, and stipends. The NCAA controls their terms and conditions of employment, including maximum number of practice and competition hours, scholarship eligibility, limits on compensation, minimum grade point average. The NCAA does impose caps on the number of scholarships that may be given out by a university. The universities control the manner and the means of the players' work on the field and various facets of their daily lives to ensure compliance with NCAA rules. For example, the university maintains detailed itineraries regarding the players' daily activities and football training. And if you go look at the regional director's decision, you'll see that. I didn't go into detail about, I didn't break down the number of hours, when I summarized, but, some days could start early in the morning with check-ins and then workouts and then study tables and then watching game footage, et cetera, and so forth. In addition, obviously, to practice. So where did the road take us after 2017 to 2018, when there was a new general counsel, Peter Robb, and he rescinded General Counsel Griffin's memo, GC 1701. So from that time forward, the General Counsel's office was not taking the position that they were employees. And then that brings us to our new and present coach, who went back to the old playbook plus some. And that's General Counsel Memoranda 2108 Memorandum. That's a little typo there. And that's what's attached to the outline, which was issued in September 2021. And that's where the current General Counsel reinstated and also updated GC 1701. So GC 2108 fully incorporates what I've covered above about GC 1701. And she emphasized that the players at academic institutions perform services for their colleges and the NCAA in return for compensation and subject to their control. And those are the two, elements of common law agency standard for employees. She noted that there have been 3 significant developments since the issuance of GC 1701 that highlight the importance of the issue and why players should be found to be employees. First, there was the Supreme Court's decision in NCAA versus Alston, and that was a unanimous decision in which the NCAA said, the court said that NCAA rules limiting certain education-related compensation offered by schools, such as rules limiting certain, such as rules that limit scholarships for graduate or vocational school, payments for academic tutoring, or paid post-eligibility internships violated antitrust law. The Supreme Court did not disturb the NCAA's rules limiting undergraduate athletic scholarships and other compensation related to athletic performance, but it did reject the notion that such restrictions are forevermore, quote unquote. In reaching this decision, the court recognized that amateurism in college sports has changed significantly from days of yore. And interestingly, Justice Kavanaugh concurred in the decision, not with the amateurism aspect, but he concurred in the decision and suggested that the NCAA's remaining compensation rules also violate antitrust law. So that would be the ones limiting undergraduate athletic scholarships, et cetera. And question whether one way of resolving the difficult questions around these issues might be by engaging in collective bargaining with the players, interestingly enough. The second development after Northwestern has been the NCAA suspension of its name, image, and likeness rules. So the players are now allowed to profit from that, and also to use agents in that endeavor, which I recently came across an article where a player was negotiating like 13 million. I'm sorry, I can't remember his name, but the dollar figure around the agreement that he was seeking to make with whoever was willing to pay him for this was like $13 million. So I'm sure that that's sort of a unicorn situation, but still. And this happened while many states were ready to enact laws granting players NIL rights. So many of these laws were set to take effect anyway. So the NCAA sort of got ahead of it and rescinded this rule. The general counsel noted in her memo, the freedom to engage in far-reaching and lucrative business enterprises makes players at academic institutions much more similar to professional athletes who are employed by a team to play a sport while simultaneously pursuing business ventures to capitalize on their fame and increase their income. So thirdly, the general counsel noted the third sort of development was the increase in collective action by players around sports injuries and safety, around racism on campus, around Black Lives Matter movement after the killing of George Floyd, and COVID-19 safety issues, and also protests related to sexual abuse. So all of these topics relate to the terms and conditions under which they play, i.e. work, and were issues that many players were already coming together around and protesting about or going to the administration about. So these would be considered in the general counsel's view, players who are engaged in protected concerted activities to improve their working conditions. And that in doing and engaging in these activities, these players should be protected from retaliation. So the plus play, in addition to announcing that you will be taking the position that these players are employees, GC Abruzzo added that she views misclassifying players as student athletes and leading them to believe that they have no rights under the act in and of itself violates the act because it has a chilling effect on their Section 7 activity. So, I don't know, I mean, we all call, you've heard me, I keep tripping over wanting to say, I've had to train myself to say players at academic institutions as opposed to student athletes. We so commonly use that. But in fact, she references an article in the memo, which I've noted here, where the author describes the NCAA's sort of use of the term student athlete as a strategy to limit their protections as employees. So there's some background to that term. So, you know, I encourage you all to read on that. There's also, she references this HBO documentary. I've not looked at this, but I will. And in this documentary, they take the position that the NCAA intentionally misclassifies these players as student athletes to avoid providing protections and benefits under employment laws, including wage and hour, workers' compensation, health and safety, and unemployment benefits, as well as under labor laws. And they describe how doing so institutionalizes racial segregation of workplace protections, which I find to be very interesting as well. So I will be taking a look at that. So I've provided the memo. Obviously, you guys can read it in more detail. There are lots of other articles cited in there as well. I provided at the end of the outline some other articles and resources for everyone to take a look at. I do want to emphasize here the purpose of this memo, GC 2108, which is to educate players and the public of their rights and to announce to the public that in future cases, the NLRB regional offices will look at these criteria to determine whether or not players who may come before the board, whether in a representational context or primarily in an unfair labor practice context, are employees. Do they provide services to the university, the NCAA, or the conference in which they play? Are they subject to the control of these institutions or organizations? And are they compensated by the institution or the organizations? And take note, as I said, compensation is not required under the common law test, although it is a very important factor. So we are not at the place now, obviously, where the board has found these individuals to be employees, although obviously if you represent an institution, private institution, academic institution, and their players decide that they want to file a petition with us, or they want to file an unfair labor practice because the employer has classified them as student athletes, or the institution rather has classified them as student athletes, you could still find yourself obviously answering to an unfair labor practice charge. So where are we? The referees are reviewing the play. When will they make the final call that may be subject to further review? What does all of that mean? So this issue may not be answered dispositively for a couple of years, if not more. And that's because first it has to make its way before the board, and then the board has to agree to make a decision, to make a ruling. And even after that, board orders are not self-enforcing. And so after the board issues an order and decision, it has to be enforced in the circuit courts. And the party who may be on the losing end of an order also has the right to request the circuit court to review the decision and to not enforce it. And of course, there's more than one circuit. So you might have, it may make one case might make its way to one circuit. Another case might make its way to a different circuit. There could potentially be a split in the circuit. And ultimately, it might make its way up to the Supreme Court. I'm not saying that's where it's going, but that's where it could potentially go. So even when the board issues its decision, there might still be some ways to go. However, when the board does issue a decision, the agency is bound to follow board precedent. So even though a circuit court doesn't enforce a board order, that just means the board can't collect on the judgment or the order, but any cases that continue to come through the pipeline, when that issue comes before the board is going to apply its own precedent until either it decides to change that precedent or the Supreme Court for some reason rules against that precedent. So there are a few cases that are pending before the agency now and are actually maybe making their way to the board. The main one here is University of Southern California. So that this one this is a UOP charge that was filed against USC, and it also named the Pac-12 and the NCAA as joint employers of the players. It was filed by the National College Players Association, and that's the one in the middle. I'm sorry, that's case number 31 CA-290326. Any information that's public about that case, you can go to the board's website to look it up to see any documents that have issued in that matter. It was filed by the National College Players Association and alleges, one, that USC has misclassified the players as student athletes, and that, two, it is maintaining rules that chill Section 7 activities, including rules restricting communications with their parties in the media and in social media. So in this case, actually, there has been a decision to issue complaint. And so the case might make its way up to the board. And that's the only one that we have right now at that posture. And it also raises a joint employer issue. So that's a very interesting issue as well. Because it's one thing to hold the USC accountable, but another thing to hold the Pac-12 conference and the NCAA accountable in this case for an unfair labor practice. And the question there is, if they are a joint employer, which is a legal, a status that is determined by applying a legal standard, then they are equally culpable for the unfair labor practices. And you've heard during the presentation how much control that the NCAA and the league conferences do exert over the players. And so based on that, the general counsel has decided to issue complaint and include both the conference and the NCAA as joint, and plead them as joint employers. Of course, an administrative law judge may or may not agree with that position. It still has to be litigated. I believe the third case listed here, UCLA against UCLA, that is case 31 CA 290328, was withdrawn. And of course, you'll note there that UCLA is a public institution. So we would not have jurisdiction over UCLA. And I think the first case, the Region 25 case, which that first number there refers to the region in which the case is coming out of, or where it was filed. I think that one's being held in abeyance pending a decision in the USC case. So that's where things stand there. And I thought I would open it up. I will open it up to questions. We've got a couple of minutes, but here are some other articles of potential interest. These articles were all compiled by the panel who presented at the national conference last year on this. So, and that panel was comprised of a professor, I think, and an attorney who represented universities and colleges, and also the regional director of our Oakland office. So I trust they did a good job of compiling a list of articles here that really sort of present both sides of the argument. Okay, that concludes my presentation, and I will open it up to questions.
Thank you. This is amazing. This is very good.
Yes, it's pretty significant development.
Very significant.
Mhm.
We're out of time, but does anyone have any questions, or anyone want to stay around for a minute or two to ask, to discuss? It's very comprehensive. We appreciate all of the additional information.
Sure.
This is a terrific resource. We really appreciate this handout.
Yeah, that was.
There's a lot of info there that we can go back to, and as we're curious about it, look at more information, the case law on it in particular. Really appreciated.
Mm-hmm. Well, thank you all very much.
Thank you.
Everyone have a good day.
And for those of you that are still on here, we do have another one of our virtual Arbitration Academy courses on Friday. So if you are interested in attending, please sign in. It will be the same Zoom link as it was in weeks prior. If you need a copy of that Zoom link, if you've lost yours, just let us know, email myself or Mita. We can get you a copy of the link again. But otherwise, thank you so much for attending today, and we'll look forward to seeing you on Friday.